The purpose of this course is to explain the process for collecting payment for building and construction work or goods and services supplied using the security of payment process. At the end of this course, you will understand the security of payment process, the key features of the process, how to issue a payment claim, and what your responsibilities are under the process as both the builder and the client. You will also understand how the security of payment process relates to the building contract, whether it be written or oral, and how it compares to other payment enforcement and dispute resolution processes. Each screen will automatically proceed to the next unless you are advised otherwise. Security of payment is a process enshrined in legislation to assist service and product suppliers in the building and construction industry, such as builders and tradespeople, to quickly and easily get paid for work done without having to resort to expensive litigation and legal costs. The security of payment process is only applicable to commercial builds and owner builders, except in Tasmania, where the builder, service or goods supplier can use it to recover payment in relation to residential and domestic buildings. The security of payment process uses adjudicators to make determinations on liability of the respondent in relation to a payment claim. The adjudicator can also apportion the cost of the adjudication between the parties as the adjudicator determines as appropriate. There are strict timelines imposed by the legislation, and failure to meet those timelines has significant repercussions. The purpose of these strict timelines is to keep costs down and ensure any dispute is resolved quickly. It takes about 5 to 7 weeks from the issuing of the payment claim to the making of a determination by the adjudicator. The security of payment process. It is not necessary to understand every aspect of the legislation. There are, however, some key concepts that you must understand. Whilst they will be explained in detail later, I will introduce them to you now. The initial requirement is that there needs to be a building and construction contract, written or oral, for the provision of work, goods or services within the state. If the work is done outside the state, you cannot use that state's security of payment process. The next key concept is the reference date. The reference date is the day you are entitled to send your payment claim for work done. The reference date will either be a date set by the contract, otherwise it will be the date set by the Act, which is the last day of the month in which the work for which payment is being claimed was done. You can only claim for work done or goods supplied. The bill or invoice for your services or goods is called the payment claim under the Act and must contain certain information to qualify as a payment claim under the Act. We will go over the actual requirements later. When a payment claim is sent to the client should respond with a payment response. A payment response states what amount the client will pay, if any, and if the client states it will pay less than the amount in the payment claim, the client must state the reasons for not paying the full amount. The two documents of payment claim and payment response are the key documents which set up how you proceed under the Act. We will deal with this in detail later. For now, It is important to remember that there must be a building and construction contract, written or oral, for goods or services provided within the state. The reference date is when you are entitled to send a payment claim. The payment claim is the demand made for payment under the Act. The payment schedule is the response to the payment claim made under the Act. The security of payment process does not change the operation of your rights and liabilities under the contract. Indeed, the adjudicator must take the terms of the contract into consideration when making any determination. The Act specifically preserves all rights, but if there is any provision in the contract that attempts to exclude or restrict the operation of the Act, then the term is rendered ineffective. The security payment process. If you take a quick look at the security payment process compared to other debt collection and dispute resolution processes, you can see that security payment offers a simple, inexpensive, and timely solution. It is also one of the few methods that does not require you to spend time away from your work to attend a mediation, tribunal, or court hearing. Often with these processes, especially tribunals and courts, you can spend days sitting around with your legal representative, waiting for your matter to be dealt with. This costs money, and with small to medium-sized debts can often not be worth it, because even if you are successful, you may pay out more money chasing the debt than the amount you are owed. Attendance at such hearings can be unpleasant and emotionally draining. Virtually all other methods require you to engage a lawyer, which in itself is costly and produces its own delays and frustrations. The security payment process clearly is the most obvious process to use and gives the best overall outcome for your business. Before going into each step of the security payment process, we will have a look at the overall process. The flowchart you see on the screen now gives a general overview of the process across Australia. In the Security of Payment Submission Writer manual you can download when you have registered with the site, there are detailed flowcharts with timelines explaining every step or possible step. It is recommended that you print out the applicable flowchart for your state and use as a reference. To begin the process, you need to have a building contract for work, goods or services. The Act defines what such a contract is and what construction-related goods, services and work are. A copy of the Act for your state is available in the Resources section of the Security of Payment Submission Writer website. Generally speaking though, if you think you are in the construction business, then you most probably are, as the definition captures what the ordinary person would see as building and construction work, goods and services. Next, you need to have done some work. The right to serve a claim for payment does not arise until the reference date has occurred. The reference date is the date under the contract or the Act upon which you may send an invoice. This invoice is known as a payment claim. Once you have given your payment claim to the client, they have a period, as previously mentioned, to give you back a payment schedule. A payment schedule, like a payment claim, must contain specific information to be valid. If the client does not give you a payment claim in the time allowed, you can do one of two things. One, you can go to court to get your money, or two, you can decide to go to adjudication. If you decide to go to adjudication, you must give them a second chance to give you a payment schedule. The reason for this is if the client has not given you a payment schedule and you go to adjudication, they usually cannot raise any issues against you being paid. If they have given you a payment schedule and you are not happy with it, you can go to adjudication. To apply for adjudication, you complete an adjudication application explaining why you are entitled to the money. You send this application to the nominating authority, who has been appointed by the government to administer the adjudication process. The nominating authority has approved adjudicators and will assign an adjudicator to your matter. The other side may submit an adjudication response arguing why you should not get the money. They can only do this if they have previously given you a payment schedule. The adjudicator will look at the submissions and give a decision in writing. This decision is binding on the parties. If the client does not pay according to the decision, you may ask the nominating authority for a certificate of the decision, which, if filed with the court, you may then enforce like any other court decision. In the flowchart on the screen, the blue refers to the person claiming the payment, the reddy brown to the client, and the green is for the adjudication process. The benefits of the security payment system is that it is quick, effective, and not expensive when compared to the courts. The process is simple and does not require the use of lawyers. There are no complicated forms or hearings. The decision is provided in writing within 10 business days of the appointment of the adjudicator, unless the parties agree otherwise. Also, a full written decision and reasons are given to you, so you can understand why the decision was made. In many courts, the judge or magistrate may give a decision without reasons, or at least written reasons. In many cases, they will deliver their judgment as an oral judgment. This can mean it is difficult to understand why the decision was made, or use such a result to improve your business process. As the matter is determined on the papers under the security payment process, you do not have the stress and expense of having to go to court and be subjected to a hostile opponent. You also do not lose time by sitting in court when you could be out earning money. The starting point for the security payment process is the existence of a contract for building or construction work, goods or services. The Act defines building and construction works and also building and construction related goods and services. These definitions are extensive and you should read them. A copy of the Act for your state is included in the Resources section of the Security of Payment Submission Writer website. As you will see, the definition is extensive and covers areas which you would not normally consider, such as the supply and installation of carpet from a carpet retailer, or the purchase of a hammer from a hardware store by a tradesperson. The contract must be for work within the state or for the supply of goods or services originating from the state in which you wish to pursue the claim. The contract may be written, oral, or a combination of both. As the terms of an oral contract are often difficult to prove, it should always be your practice to have a written contract, even if these are terms printed on the back of a quote. Having a written contract also allows you to include terms to protect your interests and make the collection of money easier. You are restricted by the Act from having some terms in your contract. You are prohibited from having a clause which attempts to exclude the operation of the Act, and you cannot have a term which states you will pay a supplier of goods or services when you are paid by your client. The purpose of the first prohibition is obvious. The second is to prevent a head contractor from delaying payment to subcontractors by making the payment dependent on receiving a payment from their client to the head contractor. Once your contract is in place, you then need to do some work or provide some goods or services before you can issue a payment claim. The security of payment process requires two things to have occurred before you can send a payment claim to your client. The first is that you have actually done work or supplied goods or services. The Act essentially only allows you to claim for things you have done. Secondly, the reference date has to have occurred. The reference date is the date in the contract or under the Act you can issue an invoice to your client for work done or goods and services supplied. If the contract does not have a date for the issuing of invoices or payment claims, then the reference date is deemed by the Act to be the last day of the month in which the work was done. It is therefore important you clearly have stated in your contract when you can issue invoices, payment claims, and when those invoices or payment claims must be paid.
Essentially, a payment claim is nothing more than an invoice. It can only be for work done or goods and services supplied. It has to be endorsed with the words stating it is a claim made pursuant to the Act, and it needs to correctly identify the client, their address, and have sufficient detail so that the client can understand what the payment claim is for. Whilst there is no hard and fast rule for the amount of detail to be given, a good rule of thumb is that the detail should be sufficient so that a person who has no knowledge of the project can understand from the payment claim alone what the claim is for. The reason for this is the client is entitled to know what they are being charged for and enables the client to raise any issues or concerns regarding the amount claimed. The detail may be given by referencing another document the client already has, such as a quote or schedule of works. It is important that you have a date for sending the payment claim and also a date for payment of the payment claim in your contract. If you do not, then the Act will deem dates which may not work in with your cash flow requirements or business needs. If you don't have dates set, then you can only send payment claims generally at the end of each month, and the date for payment by the client will be determined by your Act. Please see the adjudication process flowcharts in the Security of Payment Submission Writer Manual for exact timelines applicable to your state.
The payment schedule is the client's written response to the payment claim. For a payment schedule to be a payment schedule under the Act, it must identify the payment claim it is responding to, indicate the amount of the payment, if any, the client is intending to make, and if the amount is less than the amount in the payment claim, state why the lesser amount or no payment is being made. The last item is very important because as the client may only raise matters put in the payment schedule if the dispute goes to adjudication. The only exception to this is in Victoria, which allows a client to raise issues in their adjudication response which are not included in the payment schedule. When putting reasons into a payment schedule for non-payment, you do not need to include a full legal explanation, only the reasons, such as the work claimed was not done or the work was not to standard and the contract allows the client to withhold part payment. It is better to list a reason you might want to rely on than not use that reason in the adjudication, rather than not list a reason that you may then want to rely on later. If you fail to serve a payment schedule, then you may not put a adjudication response. After service of the payment claim by the contractor, what happens next depends on what the client does regarding the payment schedule. The client may either serve a payment schedule on the contractor, which offers to pay all the amount, part of the amount, or none of the amount claimed. Or the client may do nothing and not do a payment schedule. We will first look at what happens if the payment schedule is not served. If a payment schedule is not served, the amount of the payment claim becomes due and payable, interest applies, and the contractor may issue a notice to stop work or in some jurisdictions place a lien over the work goods. The contractor has three options: go to court, do nothing, or go to adjudication. If the contractor chooses to go to court, they may ask the court to order recovery of the unpaid part of the payment claim. In such proceedings, the client generally may not raise any arguments in defence or bring a cross-action. The process will usually need the contractor to engage a lawyer and could be costly, especially if the amount claimed is large and you need to go to a higher court. Before embarking on this course, you should consult a legal advisor. The contractor also has the option of doing nothing, but rely upon the fact that the debt is due and payable under the Act, and that they could go to court, with the client being unable to defend the action as a negotiating strategy to get payment from the client. The third option is to go to adjudication. If the contractor wants to go to adjudication, then they must serve a notice of intention to go to adjudication, as now showing on the screen. This must be served on the client before the contractor may lodge an application for adjudication. As you can see from reading the note, it gives the client another opportunity to lodge a payment schedule. If the client serves a payment schedule within the time allowed, the process proceeds as set out in the next screen, dealing with the situation when a payment schedule has been served. If the client still does not serve a payment schedule, then the contractor may lodge an adjudication application and the client will not be entitled to serve an adjudication response. You can see why it is essential that you always serve a payment schedule. If the client serves a payment schedule, they would have stated in the schedule what they are prepared to pay, and if not the full amount, why they are not paying the full amount. The contractor has two options here. The first is, if the contractor accepts the reasons the client has offered for payment or part payment or non-payment, then the contractor can wait to see if the client pays as stated in the payment schedule. and the matter is then at a close. If the client does not pay according to the payment schedule, or the contractor does not accept the client's position as stated in the payment schedule, the contractor can apply for adjudication. This is done through a nominating authority. A nominating authority is a body authorised by the government to administer the adjudication process under the Act and to provide qualified adjudicators. The Act sets out strict timelines as to when you may lodge an adjudication application. Essentially, there are three situations. The first is when the client has served a payment schedule promising to pay the full amount by the due date, then does not make the payment. The second is where a payment schedule has been served, but the client disputes the claim, offering to pay only part or none of the payment claim. The third situation is when the client failed to serve a payment schedule and the contractor has issued a notice of intention to go to adjudication. In each case, there is a specific timeline that the claimant must adhere to. Failure to comply with the timeline will extinguish the claimant's right to go to adjudication on that payment claim. It may be possible to include the amount of that payment claim in a future payment claim, but this will depend on the circumstances of the particular case. Once you have a right to lodge an adjudication application, the next step is to prepare it. We will now look at the preparation of the adjudication application. The adjudication application is made up of three parts: the application form, the written submission, and the attachments. Starting with the application form. While there is no prescribed form, each nominating authority has its own. You can see the one for Adjudicate Today on the screen. Security of Payment Submission Writer will automatically generate the application form for you. The form contains the basic information to describe the parties and the amount in dispute. The submission is the guts of your application. It is in the submission you advise why you are entitled to be paid the whole amount of your claim and counter any arguments from the client for non-payment. If there is no payment schedule, you must still explain your entitlement to the amount claimed in the payment claim, though you can of course be a lot briefer than when there is a payment schedule. Your submission should give 1. A brief history of the contract and your dealings with the client. 2. What the payment claim is and why you are entitled to be paid and how the amount was calculated. 3. Counter any arguments raised in the payment schedule, if any. 4. Ask for interest to be awarded and for full costs to be awarded against the client. These are the essential elements of a good submission. In the training section of the Security of Payment Submission Writer, you have access to a course specifically designed to teach you what makes and how to write a good submission. We will now look at the third part of an adjudication application, which is the attachments. Attachments are not just dead documents hanging off the end of your submission. Each attachment has to be there for a reason, and that reason explained in your submission. Often people make the mistake of putting in attachments and not properly explaining what the attachment shows or is meant to prove. Attachments do not have to be just documents. Whilst generally they will be, you can attach photos, video and audio recordings. Again, do not rely upon the attachment explaining itself. Make sure you spell out in clear and concise terms why you have included the attachment and what it proves and why it proves it. Do not take for granted that the adjudicator will understand why an attachment is there. Generally, must-have attachments will be the contract, the payment claim, the payment schedule, if any, evidence of service of all notices and claims, and a copy of all served notices and claims, and an explanation of how you have calculated the payment claim amount. The adjudication response can only be lodged and served when the client has provided a payment schedule. Even then, except in Victoria as previously explained, the client can only raise those issues that have been raised in the payment scheduler. Apart from that, the points and advice given for the preparation of the adjudication application apply to the adjudication response. Once the application has been lodged with the nominating authority and a full copy served on the client, the nominating authority will appoint an adjudicator. It is the nominating authority you and the client will deal with. The parties have no direct contact to the adjudicator unless the adjudicator requests a meeting. The adjudicator will be given a copy of the adjudication application and the adjudication response. Under the Act, the adjudicator must take into account the Act, the contract, the payment claim, the payment schedule, if any, the adjudication application submission, and the adjudication response submission, if any. The adjudicator will normally determine the matter on the documents only, but the adjudicator may request further information, a site inspection, or a meeting of the parties. Apart from the occasional request for further information, directions for a meeting between the parties or site inspections are very rare. It is for this reason your documentation has to be spot on. The adjudicator must, within 10 business days, unless the parties agree otherwise, make a determination in writing giving reasons for the decision. The decision will normally include the interest on the outstanding debt, if there is one, and which party is responsible for the costs of the adjudication. Generally, the adjudicator will award the costs of the adjudication against the losing side. The determination will be released by the nominating authority once payment has been made with the adjudication fees. Often this means the claimant will pay the fee and then recover them from the client. If the adjudicator finds an amount to be due and payable, the amount, together with the adjudication fees, if awarded against the client, must be paid within 5 business days. If the client does not pay as directed by the determination, the claimant can request the nominating authority to issue an adjudication certificate, which the claimant can then file with the court as a judgment debt and have it enforced in the normal manner, such as seizing goods.
Before moving on to a recap of the whole security payment process, I just want to mention a few additional points. Once your payment claim becomes due and payable, you can in some states put a lien over the work or goods. If your state does, it will appear on the screen now. If not, then this option is not available in your state. Secondly, whilst a contract normally gives you the power to suspend work when a client has breached the contract by not paying, you can also suspend works under the Act. The advantage of suspending works under the Act is that, given it is a legislative right, you cannot be sued for breach of contract. The third and last point is that the security payment process is all about documents. It is therefore essential that you keep your project and administration files in good order. This will save you a lot of time and money. To quickly recap the security of payment process in Queensland, firstly, you need a building and construction contract. You need to have done the work or supplied the goods for which you are claiming payment. You need to have an entitlement to serve the payment claim under the contract or the Act. The client has 10 business days to respond with a payment schedule. If no payment schedule is served, you may apply to the court for an order, or you may serve a Section 21(2) notice of your intention to go to adjudication. If you serve a Section 21(2) notice, it must be served within 20 business days from the date due for payment of the payment claim. The client has another opportunity under the Section 21(2) notice to serve a payment schedule within 5 business days. If a payment schedule has been served in response to the original payment claim, or a Section 21(2) notice has been served, you may lodge an adjudication application. This must be lodged within 10 business days from either receipt of the payment schedule or after the Section 21(2) notice has expired. The client has 10 business days to lodge an adjudication response from the receipt of the adjudication application, or 5 days from the receipt of the adjudicator's notice of acceptance, whichever is the latter. The adjudicator has 10 business days from receipt of the adjudication response or the date the response would have been due to make determination. The adjudicator makes the determination and the client has 5 days to pay according to the decision. If the client fails to pay, the claimant may get an adjudication certificate from the nominating authority and register the certificate with the court as a judgment debt.
Congratulations! You should now understand how the security payment process works in your state, appreciate the importance of complying with the time requirements set out in your Act, how to go about making an adjudication application and response, the purpose of the notice of intention to go to adjudication notice, the role of the payment claim, and the payment schedule. As the adjudicator will determine matters on the documents, if you know how to put together a powerful submission, you are going to have a distinct advantage. Using Security of Payment Submission Writer will allow you to do this quickly and easily, as well as giving you access to a range of services and support to help you in your business. We recommend that you now undertake the how to write security of payment documentation course, which is available in the training centre on the Security of Payment Submission Writer website.